First of all, let me just comment generally that the anti-SLAPP world has grown in terms of subject matters that it covers, recently probate, and it has a way of being tremendously appealing because it is a way of jumping to the merits without the usual hoops often in most cases. There's also difference between state court and federal court, which you'll hear about, but it is an enormously powerful weapon. Generally, when I get calls for people whose boyfriend or girlfriend has defamed them on Facebook, I tell them that California is probably the worst place in the country in which to sue for that cause of action, explaining the SLAPP laws. Let me just forward the slide to the next one. The basics are twofold. Everybody in the SLAPP universe refers to them as Prong 1 and Prong 2. Prong 1, the defendant, and this is the burden of the plaintiff. This is the burden of the defendant who is filing the motion. The defendant must establish that the challenge claim arose from activity protected under the statute. Two kinds of activity are protected. One is petitioning activity and the other is free speech. Prong 2 is very unusual because the burden then shifts to the other plaintiff, to the plaintiff, to demonstrate the merits of his claim. He has to be able to plead and prove a prima facie case. So the complaint on its face must state a claim, but he also has to show that he has the ability to put on a prima facie case. At that point, if it is a SLAPP case, that is to say it is about petitioning activity or free speech, and if the plaintiff has passed his burden, then the case proceeds as a normal case. But let me just talk first to the issue of procedure, and I'm passing the microphone on to Steve Raucher.
Thanks, Howard. So there is a ton of ground to cover today, just in the past 18 months or so, which is what this program will focus on. There has been a tremendous amount of case law, and so we will do our best to plow through it. I think probably we should try to hold questions for the end because there is so much to get through. But just to give you a little bit of an overview of how we're going to divide this up, I'm going to spend about 20 minutes talking on some of the newest procedural issues that have been clarified in the past 18 months or so. We're then going to get into the meat of the anti-SLAPP statute a little more, with Dan focusing on Prong 1, because there have been a ton of cases on Prong 1, as there always are, what does arise from protected activity and what doesn't. And then we're going to turn it over to Howard, who's going to even drill down even further onto the question of what constitutes an issue of public interest for purposes of Prong 1. So a lot of ground to cover. And if I'm running out of time, I may skip a case or two, but all the cases are listed in, the PowerPoint presentation is in the email that was sent to you. And Dan, if I'm like running up against time, don't hesitate to sort of elbow me, because I want to make sure that you guys get your due time. The first case that I want to talk about is one of a couple California Supreme Court cases in recent days or months to deal with issues of procedure, and this is called Newport Harbor Ventures. And specifically what this case addressed is, what does the 60-day deadline for filing an anti-SLAPP motion? The statute 425.16 subsection F says that an anti-SLAPP motion must be filed within 60 days of the service of the complaint, and the court has discretion to allow a later filing as well. In this case, the defendants filed their motion within 60 days of the third amended complaint. So was that timely or not? The third amended complaint contained both old and new causes of action, And what the Supreme Court held is that because the purpose of the anti-SLAPP statute is to allow early resolution of SLAPP lawsuits, but at the same time that the courts have to be careful not to allow the anti-SLAPP statute to be used sort of as a gamesmanship ploy, you have to file that SLAPP motion within 60 days of the earliest complaint that contains that cause of action. So in this particular case, what that meant was that the defendant could only challenge the newly added claims in the third amended complaint via the SLAPP motion. Even if some of the old claims could have been subject to the SLAPP motion, it was too late. Subject to the court's discretion, which does still exist to allow the late filing. And the other clarification I thought was worth keeping in mind is that the rule applies not only to new causes of action, but if there are new allegations in the new pleading that make a previously pled cause of action slappable, then the motion is still timely as to at least those aspects of the old cause of action. Okay, moving on to Bel-Air Internet. The question here is, what should the court be considering under Prong 1 for determining whether the defendant has met their burden to show that Prong 1 applies? Specifically, when a plaintiff's complaint shows that a claim arises from communications that are protected under the statute, must the defendant support the motion to strike with declarations confirming that his or her actions fall within one of the categories of protected conduct? And the answer to that was no. Where the complaint itself alleges protected activity, the moving party is not required to submit declarations or anything else. They are entitled to rely on the allegations in the complaint to meet that burden. Although they can, if they so choose in an appropriate case, also supplement what's in the complaint with declarations in an attempt to meet that burden. But the facts of this case sort of illustrate why this rule is necessary. The plaintiff in this case alleged that the defendants encouraged fellow employees to quit and sue their company. The suing part is what was important for Prong 1 purposes. And they alleged intentional interference with contracts. The defendant, in their motion, submitted a declaration denying that they had encouraged the other employees to quit and sue. Why did they do that? Well, they didn't do that for Prong 1 purposes. They did that in anticipation of Prong 2 purposes. But the trial court looked at those declarations and said, well, and according to your declarations, you were not actually seriously considering suing the plaintiff, and therefore you, defendant, have failed to establish Prong 1. Oops, I think I missed a slide there. So what the Court of Appeals said is that no, you are allowed to consider just the pleading, and you do not take yourself out of Prong 1 as the moving defendant by submitting declarations which deny what you're accused of. If obviously you're entitled to have your factual defense to what it is you're accused of, and you wouldn't truthfully be able to provide declarations that acknowledge what it is you're accused of. And so in looking at Prong 1, the trial court should have constrained itself just to look at the allegations of the complaint for Prong 1. That does not preclude you, by the way, from doing what the plaintiff did here, which is submit declarations in anticipation of Prong 2, which obviously contradict the allegations in the complaint. Okay, let's move on to the next California Supreme Court case on procedural issues, which raises a number of kind of interesting questions. What kind of evidence may a court consider on an anti-SLAPP motion when you're talking about Prong 2, the probability of success? In this case, the school district plaintiff sued the construction company to void construction contracts on the ground that they had been procured through bribery. The defendants argued that their bribes, which included some campaign contributions, constituted protected political expression, and that was the basis for satisfying Prong 1 under the anti-SLAPP statute when they filed their SLAPP motion. That issue was not challenged at all by the Supreme Court. So prong one was taken as a given.